All right, hello everyone, and welcome back to another episode here. This is a resurrection of an old PowerPoint that I had done, and this one was geared as we were studying the judicial machinery of the court. Remember the Bullock case when it judge specifically mentioned fraud upon the court is fraud upon the judicial machinery of the court. So when you look at the picture here, the pictorial version of the scale of justice, for example, this is the machinery to which they are referring, right? This is a pictorial representation of that machinery, right? Or what most people would perceive it looks like. So beginning from that representation, we'll go ahead and start getting into the presentation here on in this particular PowerPoint was actually fairly long. I've removed some of the content from it, and I did add a couple of things that were not here that needed to be here. So I'm going to get into emoluments and causes of action through various types of writs or other congressional process. Okay, so in order to do this, we're going to get into some of this machinery, right? We've got to start with that. So before I dive into all that, E-clause is a lawfully created entity, right? This work product does fully comply as specified under Florida Constitution, Article 1, Sections 1 and 6, exercising political power and right to work. And disputes for that could be, you could find those disputes on page 17, Section 7 in the Mason's Manual. Hence, the constitutional provisions are mandatory. So what is this company, right? We say, well, if we're going to build something, let's start with a corporation and go from there, okay? So here's the articles of incorporation, right? For lack of a better expression, right? As you see, everything is signed off on by the Department of State. So I am now incorporated, right? We'll get into on and off the clock as we go along here. So benefits of incorporation are mandatory oversight. Moves your questions to the front of the line to begin the oversight process or processes through the General Assembly and state executive agencies. Such the examples are the remonstrance, or as I call it, remonstrance. If you've ever read one of my 1,000+ page documents, you'd understand. Or other grievance process, lawful notifications, parliamentary inquiries, or other types of questions. Basic special purpose motions to the body, and of course, establishing your proper standing to assemble a special session of circumstances mandated. Okay, this is where we talk about your standing in law. So see your state's House and Senate rules and research which book of process is primary choice for your state. Here in the state of Florida, the primary books are Jefferson's and Mason's. You can find that in the General Assembly's rules. So those books are pictured here, okay? You'll see Jefferson's off to the right. This is the primary one that's utilized for impeachment, right? Those of us in position of emolument who are on the clock. So if you have an oath of office and somebody holds you in contempt or whatever, before they impeach you first, they just usurp due process. Hence my joking question, am I on or off the clock? Because if I'm on the clock, you as the bad actors in my particular case usurp due process. I wasn't given I wasn't afforded proper due process of law. You had to impeach me to remove me from my emolument first. Somebody's got a problem. Anyway, moving forward, The other manual here in the state of Florida is Masons, one over here on the left. And some of the states, I believe Indiana and a couple other ones, Illinois, they also use Roberts, and some of the local jurisdictions also use Roberts. Now, the nice thing about Roberts is, in conjunction with Masons, is there's flow charts in Roberts. So the question becomes with your local assembly is, well, what do you mean you want to do X? Is that in the flow chart, right? You can even find it in the book. So if you can't find it in the book, how are you making a rule on it, right? I mean, it hence parliamentary inquiry or request for other information. You can include just about anything into your corporate entity and protect it under the corporate veil, right? That is things like real property, like land and structures, fleet or vehicles, personnel, human resources, contracts, personal credentials, and other things, and of course other assets you designate: books, papers, files, research materials, etc. In other words, capital gains are why they're all shown in blue, right? These are your corporate assets, right? So your basic company structure, right? Again, taking this from the Republic, the executive side, right? Executive branch is broken up into two, right? Your chief executive officer or CEO, that would be the president in government or governor in the state government, and your chief financial officer, which is in government. Federal government is the vice president. In the state government, the lieutenant governor, okay? So this way you kind of get an idea of the command structure and why these things are the way they are. Boards of directors or Congress, depending on how big your company is, sometimes it'll be one entity, sometimes it'll be two. So there's no set structure. So yours can be constructed as you so desire, depending on your company's needs, size usually being one of them. So split boards of directors, separating options being the Senate, right? And finance being the House of Representatives, the side that controls the purse, the spending, the finance. It would work chiefly with the CFO, right? So, depend on, what type of funds are going to be needed to execute whatever kind of campaign your company is going to exercise. So anyway, keeping it simple will aid in any potential audits or other periodic inquiries as they may occur without a lot of advance notice. You can also use these processes to your advantage if you run things properly. For example, there's no better witness for oversight on your behalf than a well-executed government audit, which finds no fault with your company or its business practices. Another benefit to keeping everything lawful, right? Difference between legal and lawful, and we're going to get to that as we. So here's my oath of office, right? There's the word emolument, right? Or it's actually in its plural form, emoluments. That being said, okay, we're going to go with its plural form as we go down through and establishing what jurisdiction is, right? So as a licensed professional, research is also appropriate, especially when you're talking about the difference between a lawful contract versus a legal contract. Because if a contract is not lawful, it is not legally enforceable, right? So if we're going to do business in commerce and be within the letter of the law, right? So this, of course, is research and development, right? Direction of changes. This is one of the primary benefits of being a for-profit entity, is that research and development of any project can often take turns and twists you never see coming at the inception of any project. For-profit companies can utilize this to their advantage as well, since the corporate structure is conducive to losses relating to such work. Okay. In other words, many big corporations don't put all their eggs in one basket. Research and development is usually one small section of that larger structure. So be sure to keep well-constructed notes along with cited sources cited source lists as you go. You never know when an audit will pop up and require you to revisit old ground during that process, right? So just because your project changed, being able to articulate where you were and why the direction changed, right? So anytime you see that happen, by all means, keep good notes. So, and of course, judicial branch knew of loss prevention, right? We've shown that it's us being brought in through the Department of Defense in 2013. So they said, okay, we want to play too if we're going to be looking for emoluments violations, right? They said, you stand over here, right? Just follow the law and the rules of the court. It's okay, right? Easy, seems pretty easy to do. So knowing and understanding that what we're defending against is foreign emoluments, right? And the best way to go through and begin your counterclaim, okay, stating your counterclaim, is to predicate that counterclaim utilizing basic due process as it's written in the rules of the court, right? As you see the list appearing here, there's lots of good places to stand, right? And I'm going to review this list in more detail after this presentation, but kind of give you an idea of predicating, right, your defense mechanism against these foreign emoluments, defending yourself, right, in context. Well, what one does in his defense is considered legal. It's even a maxim of law. So hence the short list. So what is it that we're looking for, right? We're going to talk about what a foreign emolument is. Okay. What are those, what do emoluments violations look like? Okay, well, this SMU, for lack of a better expression, which comes from this line in the Declaration of Independence, as well as this conduct of tyrants, right? You ever wonder what the object was and what the design was, right? Well, here's the object, right? It's 13th century Latin root emolumentum, right? Hence its 4 elements, which I'm going to go into in detail here, are advantage, profit, gain, and benefit, right? This is the benefits model. So those, he has erected a multitude of new offices, right? Those offices sent hither swarms of officers to harass our people and eat out their substance, right? Those would be those ill-gotten gains, right? That's what what the offices are yielding against these bad actors in these foreign emoluments. So what is Juris, right? Well, it's a methodology of application. Okay, so in so much as color of law, right? Advantage, profit, gain. Our republic only has 3. Monarchies and other hierarchies have 4 or 5. Some even more, depending on if we're talking secret societies and all of those other garbage. Yeah, I'm not even going to get into it because that would lend credence to ignorance in my estimation. So anyway, moving on. Diction with principles. Remember the short list, those maxims of law established by the Constitution, okay, or constitutions in the context of your state. So in so much as color of law, okay, well, here's what those elements, right, of the republic, there being 3, advantage, profit, and gain, right? As we built our republic, right, our republican form, character, and form corporations, the red leg became market, right? The green leg became margin, and the blue leg became capital, okay? So your profit margin, right? This one is always the one that companies are looking at, right? So in my experience, usually the target is between 30 to 35%. So if you're hovering right at 30 or just above 30%, you're doing well. And you want to between a 10 and a 12% increase per market capita, right, per fiscal year. So some of that's, a lot of that's dictated by sales, but many other factors come into play with it, but I won't go into that. This is not a business class. So it's just focusing on the color of law, right? The methodology of juris is one half of jurisdiction. So now that we've built the juris side of this, right? And of course, now we have the diction, the letter of the law, the Constitution. Now we have jurisdiction. We have the complete picture. And the process, as outlined in the Constitution, begins with the legislative or board of directors, right? That's where your grievance process starts, right? This is where you state your claim, right? Or your counterclaim, as it may be, for those of you who are watching this. You also, pursuant to Article 4, Section 4, you serve a copy to the executive, right? So the first two legs, first two pillars, step 1, step 2, you've now met your burden of responsibility, your due diligence, all right? So by the time it would get to the judicial branch, and of course the other side's going to pull their arrogant smew that they always do, I'm motioning to dismiss for failure to state a claim. Well, now the judge can look at it and go, I'm looking right at a lawful claim. Your motion is denied. So if you see what just happened right there, overcoming the arrogance of the 12B motion to dismiss for failure to state a claim. So what you're attempting to do is resolve the conflict, right? Hence resolution. And that's going to be in another forthcoming video. Right now we're talking about jurisdiction. So you're going after resolution to resolve the conflict, right? And that process is outlined in Mason's, right? In Roberts, and of course Jefferson's, depending on who the grievance is against or on behalf of, depending on what your situation is. Also, once you've reached resolution, it's up to the executive to enforce that resolution, right? Any challenges, excuse me, as to the validity of what the resolution was, if it is enforceable, hence the contract being lawful, not right, it can't be legally enforced if it isn't lawfully created, right? So hence you can't do business, right, in commerce without a quorum, period. It's in the rules of the quorum. So if it's in the rules of the first step of doing anything, don't you think you ought to follow that process first? Because if you want the judge to say, yes, okay, now I can do this, you got to give him or her something to work with, right? So, you know, to walk in and, oh, this one, you know, they violated my rights and da-da-da-da-da. Well, did you impeach them and remove them from their emolument first? Oh, no, I didn't do that. Well, don't you think you should do that first? So, I mean, you know, if you're not going to follow the process and you're not going to follow the letter of the law, how can you expect the judge to do that for you, right? There are limits, right? Hence, in a limited government. So burden is on us, we the people. It's only a republic if we can keep it. So keep it. Moving on. So jurisdiction is stemming from the root word emolumentum, right? It's Latin, right? Stemming from points of authority or pillars of law, right? You'll hear me refer to this as we go along as pillars, right? Each pillar, from each pillar stems a branch. So now that we've established what that judicial machinery is supposed to look like, remember we've talked about where we always thought in the market side of this, the fulcrum was on the advantage. It's not. The fulcrum is right here where the colors meet, right? As I said in the beginning, right? This was one of the directional changes that came about during the research and redevelopment of the Foreign Emoluments Clause, right? So I said, if we're going to do it, let's do it right. You know, sick and tired of this crap. Nobody wants to do anything right. They're just looking for a quick fix. Well, you know, I'm not doing my job as dad if I'm not doing it right. So just because somebody else isn't going to do it right, that's on them. You know, if somebody wants to jump off a bridge, I'm not going to hold their hand on the way down. So if we're looking at the root, right, of the word, here it is, right? Our republic is based on the 15th century, you know, root. Here's the etymology, right? Etymology of the word, 13th century emolumentum, right? Profit, gain, advantage, and benefit. There they are. So this is pretty much what we have to work with right here. You know, and within each, you know, within this structure, right? Finding the elements, this is kind of like doing a word problem. Remember those story problems, you know, train A leaves New York traveling an average speed of 50 miles an hour. Train B leaves Texas traveling an average speed of 60 miles an hour. Where are they going to meet? Well, I was always the kid who wanted to know where they meet, so I knew where to put my lawn chair so I could watch the biggest train wreck in history. But anyway, I digress. That's just me being me. So, in so much as jurisdiction, right? What jurisdiction are we acting? And that's this one right here, Title 28 of the United States Code, Section 1443. And the reason we chose this one, because we wanted to raise the bar. And what I mean by that is we didn't want just anybody being able to hijack the work, right? We wanted to be able to go in and say, here's an emoluments violation under Brady, for example, and here's how I know that. Right. You know, for example, you guys just watched us do one of these for one of my clients publicly, where we literally walked in and I basically said to the judge, do you like being lied to? And were you aware of 2 reciprocity agreements between the complainant and my client? And of course, the judge was not aware of that. Guess what happened to that case? Just saying. So that series of actors who created that problem for my client are going to have some splaining to do before the Judicial Oversight Committee. So kind of give you an idea of what this is, how it works, and its origins as a defense mechanism, right, for 5th and 6th due process. So now that we've built this thing, right, there it is, right? Those are the Republic emoluments, the Republican character, form, and excuse me, color of law, right? This is on the clock. You'll hear me say the difference on the clock, off the clock. This is what on the clock looks like. Okay. So now you'll hear me say this a lot as I have that oath of office. Am I on or off the clock? Well, in being able to differentiate clearly and concisely and decisively what each one of those looks like and why, right? So now that we've established the fundamental differences, alteration of the due process over the period of time since, you know, you've watched many of our, many of our presentations on the foreign emoluments and Sharia law and everything else. This is what it looks like in the private sector, right? On the clock in the private sector. The last slide was on the clock in the public sector, right? So this is why I say, you know, when they pull out this, oh, that's a sovereign citizen. So you're basically saying I can be on the clock and off the clock at the same time. That would be a neat trick. I'd love to see you pull that one off. So anyway, out in the free market society, right, in jurisdiction 2 in commerce, market, margin, and capital, if you've never watched the stock market, you should probably do that. It's kind of an interesting process. You learn a lot about how business works just by following it, even for just a limited time. I don't recommend getting too deeply involved in it, but it's fun to watch. But anyway, this is where your rules of law happen, right? So if your rules as you do your business conflict with the Constitution, okay, let's find out exactly how we figure that out. So you're going to obviously, in the meantime, you want to keep your eye on these jackwagons, right? This is those infiltrators walking around with that benefits card, right? That are going after those stipends, right? Remember Bill Barr's answer to my parliamentary inquiry. I was thinking in terms and conditions of contracts with government as a subsidized process. It's always what it was. I didn't know anything different. So when he popped off with stipends, I said, well, that's payroll. I know what payroll is, done payroll once or twice in my day. So, right. So this is those foreign emoluments. This is the fraud on the judicial machinery of the court as outlined in the Bullock case, right? So again, me as doing what I do, I'm going down, I'm reading through the cases, and I'm saying, what is the judge looking for, right? If he or she is going to take their time to write an opinion, they're asking for something. What is it they're asking for? Well, when he said fraud on the judicial machinery of the court, you're talking to a guy whose job it was to study machines, right? I mean, hello, that's, the machinery of the corporation and all of its processes. I mean, duh. Talk about basics. That's why I said, as I started to do this, I started to think, man, I feel really bad for anybody who gets in the way of this one. So ironically, I get to play this part of Richard Cranium. I'm that, the guy with the idea. I won't even say it, but you know what I'm talking about. So in the context of in the private sector, okay, you have these different corporate officers with different job description doing these different projects, working in different departments, right? Research and development. That's where we are right now, right? The other one's marketing, right? You're going to take that to research and development. You want to market it, right? Well, there has to be an accounting for that. There's going to be human resources and shipping and payroll and all this other fun stuff, right? Involved in that subject matter. Well, since we're not making, hamburgers or hot dogs or selling car parts or whatever, we're specifically talking about this jurisdiction, right? So when Judge Sparks said, well, if you guys want to do this and you can prove a negative using calculus, that raises the bar. Use this process and protects the Sixth Amendment specifically, that basic Magna Carta due process. And we're like, yeah, now we're talking, right? So now I go back to the board, right? Congress. And I say, okay, you guys said 42-1983. The judge says this one. I like the judge's idea better because there were some foreign emoluments, some foreign actors in here pulling shenanigans while we were at work all day long. And we've theorized, researched, and redeveloped, right, hence the previous slide, what those foreign emoluments look like in context of banking, slavery, transactions of slavery, and all of that corruption. And that's why I said makes my brain hurt just to even think about it. But anyway, when you talk about, like, for example, standing your ground, right? You'll see on the front of my paperwork, I say I'm standing my ground. So what am I standing on, right? Principles of law. Well, starting with those 10 principles of the congressional oversight process or group decision making, right? Having the authority, hence the jurisdiction, okay, right? That puts me in a unique perspective. I have to do things. That's why I said I want to make sure it's done on what's done right, and we're not going to screw this up. I've had enough of that. So we've already found what the fraud is, right? The trickery or the deception and the fraud on the judicial machinery and all that stuff has been proven and it's come to pass. Yay, whoopee. So this is the kind of the snapshot of what standing your ground on principles looks like. Okay. So if you're going to, again, some of you are visual learners, that's why I put this slide together. So as you move forward, right, effective diction. A lot of these people you're going to be addressing, here's what they've heard about you, right? Oh, this person, they're one of them smelly Walmart shoppers, right? I'm sure you guys have remembered all that in the recent political spectrum. So to them, you're a smelly Walmart shopper who's incapable of tying his or her own shoes. So you have to make an effective first impression, right? So if you're going to construct any document, right, using this cover letter as an example, you need to know these principles, follow these simple guidelines. What body politic is being addressed, right? U.S. Senate Judiciary Chairman, right? Excuse me. The type of the document used, as I said, this is a cover letter. What are the rules of the body politic, right? If you can show them what the rules are, you're not one of them stupid, smelly Walmart shoppers. You're somebody who's, ooh, this person took the time to actually learn the freaking process. What are you talking about, smelly Walmart shopper? This guy knows this thing at least as well as I do. So, who are the parties / entities of subject matter in question, right? So, again, in the context of this, you know, if we're going to play corporate dead person, The Walking Dead, I said, okay, fine, I'll play Monopoly Corporation with you. This isn't going to work out well for you, but why not? Just for the sport of it. The constitutional articles in question, right? So, for example, I said right here, Article 1, Section 9, Clause 8, and the missing 13th Amendment. Referenced standing orders, if there are any, right? If there are not any standing orders, don't worry about this phase. But if there are, don't you think it would be better for you to fully disclose what those things are and why you're grieving against them, why you agree or disagree, right? In my particular case, it was, well, the judge mandated the standing because the judge knows that, yeah, I'm a licensed professional. I'm really good at this stuff. So, you know, let's get through to resolution. Can we please? So the idea being conveyed within those weaponized family court reports, right? Here's the general context of what it is, right? So it seems to be, things seem to be on a regressive trend as opposed to making progress in these Sharia law issues. I'm offering to testify before the committee to answer any questions related to my work into the Emoluments Clause, Article 1, Section 9, Clause 8, right, foreign emoluments, and the missing 13th Amendment to the Constitution of the United States of America related to the federal court cases submitted by my office, right? Remember, I'm competing against the Bar Association, right? I'm their competition. So in so much as this is concerned, I'm the enemy to these guys. Well, hey, fine. So what? I didn't create this mess. You did. You started it. I'm finishing it. More specifically, to continue where AG Barr left off with his answers differentiating stipends and subsidies, as I just said, in response to government contractors versus employees acting in an official capacity and why the fiduciary duty is critical when representing clients, right? I just stated what I needed to state right there. Who I am, what my standing is, what my status is, what my jurisdiction is, right? And I even throw something from the short list at the bottom, right? Just because that's just me being me, right? You can do that. You don't have to. Reference materials being used, legal dictionaries, legislative manuals, right? Who authored the document, right? You know, again, you're going to use something, you're going to claim it as a source. Don't you think you should know that it was published and it wasn't, you know, later found to be fictional? And somebody wrote this book called Sovereign Citizen, and the author is anonymous. Why would you write a book and not put your name on the book? That sounds like somebody's pulling shenanigans to me, but that's just me being me. So principles / practices of law employed in construction of the of your document, right? And that's why I always say I like using legal maxims, because they're easy. Those are those principles. Whether you're on or off the clock, those still stand no matter what. You're going to make a constitutional argument, you go to Section 7 in the Basins Manual. Here it is, right? These are organic in character, right? The origins. So we're going to start with the origins and go from there. How about that, right? So constitutional provisions the constitutional provisions stand on a higher plane than statutes and are mandatory. There it is in the book, right? So you didn't write it. I didn't write it. Judge didn't write it. There it is in the book. That's the legislative process. That's the place to make your constitutional argument. So any action, pretended act of legislation that has come forth, right? You can go through and say, well, somebody didn't follow the letter, didn't follow due process pursuant to Section 517. because the actions must be within the power or the vote is ineffective, right? First principle right out of the box. No motion or measure is in order that conflicts with the Constitution of the state or United States, or with the U.S. Constitution, or with treaties of the United States. Such a motion or measure be adopted even by unanimous vote, it is null and void. That means it's void ab initio. It's void from its inception. Thanks for wasting everybody's time, basically. So, and of course, we know fraud will invalidate acts. That's section 16, just a few more pages into the book, right? You know, we're barely into the first, we haven't even broken into the double-digit chapters yet, and we've already smashed this thing into how many pieces? So, you know, here's the cases that establish this process right here. It's already been tested. Don't have to test it again. It's already been there. Been there, done that, right? So now that we've moved forward, right, differentiating between on and off the clock, right? Now, as one of my colleagues so eloquently put it, she says, we the people are the higher of the two nobilities. You, the government, being on the clock, are the lower. Suck it up, buttercup, or quit. As only she could say it. So, and moving on. So as we look at this coordinate geometry, right? The horizontal line, the y-axis, is this center line right here. It goes right through the middle of x 0 times 0. And the vertical y-axis, right, goes between the red and the blue lines right through the x, right? Same. So knowing and understanding that the target is 0 errors, 0 mistakes. Will we ever get there? Yeah. Who knows? Anything is possible at this point. You know, flip a coin. You know, I'd like to get there. Do I think we'll ever get there? Probably not. But anyway, doesn't mean we can't hope. So, you know, we've been trying to get to a, a proper republic since we started this, only to find out we're right back where we started. So moving on, now that you've established what juris and diction are, right? Juris being color of law, diction being the letter of the law, you begin in the legislative branch, right? And through some of those writs or petitions for writs of habeas corpus, hence the AO 242 form, right? And I'm going to go, we've been through that just a little bit here and there. There's a writ of quo warranto, writ of supervisory control, writ of mandamus, writ of replevin, writ of recaption, writ of protection, writ of deceit, just to name a few, right? These are just the more popular ones that I've used, right? Or had access to using for whatever the reason. So fake standings such as GALs, right, or other guardians, right, guardians ad litem, well, you want to challenge those people. That comes from this Latin principle, right? Who are you and what business / standing do you possess here and why, right? Well, they walk in on this legal principle, basically how they enter, right? That's amitendo, and you want to remove them. That's amovendo, right? So you can challenge their standing on this principle and you're removing them on this one, right? This is knowing not just letter of the law, how to execute the law, right? It's one thing to understand the theory. It's something else to put it into practice, right? This is why being licensed to create lawful contracts in commerce, not only do I advocate for that, I participate in that process. So anybody who tells you that I don't is a liar. So knowing and understanding what a writ is, date back to the 12th century, which is a court's written order in the name of the state or other competent legal authority, right? Competency being one of the things that we question quite a bit. Commanding the addressee to do or refrain from doing some specific act, right? So, why would it be necessary? Well, for example, recent events being are what they are, nova causa interveniens was one of the just causes for intervention. basically meaning an intervening cause, right? So again, if you can lawfully articulate this, who you are and what your standing is and what your just cause for intervention would be, right? That's why I said it's a whole different animal here. So, you know, I don't walk in amatendo. I walk in saying, you know, hey, you like being lied to, right? I know this is all smew and it's all crap and it's all foreign emoluments, right? So, for example, if this refers to the habeas corpus as a privilege, it's not a privilege, it's a right declared. I only put it in there as privileges because I actually took that from the letter of the law. The right of habeas corpus stems, again, from due process, from the Sixth Amendment, from the Aziz of Clarendon, all the way, you know, all the way back that far, if you really want to go back that far. So to begin that process, remember the AO 242 PDF, it's posted here as well on the Patreon site. So Article 1, Section 9, Clause 2, specifically the privilege of the writ of habeas corpus shall not be suspended unless when the case of rebellion or invasion, the public safety might require it. So what does that mean? If anybody who is here that doesn't belong here, some of these invaders, right? Yeah, no, you're out of here. You don't enjoy the right of habeas corpus because you don't belong here, right? Period. End of discussion. You're not lawful. So what is a writ of habeas corpus? In the Florida Constitution, Article 1, Section 13, here's what it says at the state level, right? Follow the law and the rules of the court. So here's the law. Writ of habeas corpus shall be grantable of right. There it is. Freely and shall never be suspended unless, same thing, in case of rebellion or invasion, and of course, suspension is essential to the public safety. They'd have to prove beyond reasonable doubt that suspension of habeas corpus is justified and appropriate. So to just walk in and, oh no, I'm denying your habeas. You just usurped the law. You just trespassed a right. You see where this goes? So, you know, once you have submitted your process to the legislature, if the judicial branch denies it, guess what? You followed due process of law, and whoever's sitting in that third pillar can be impeached for a bad faith denial. They can't say, oh, you didn't follow due process. The heck, I didn't. Sent it right through the freaking legislature. What part of that did you miss? Did you not see my remonstrance? 1,000, one of them was what, 1,472 pages. How did you miss that? I think we had to replant the forest. Moving on. So, speaking of your list of motions, number 6 under incidental main motions, appeals, right? Habeas corpus is the first of the incidental main motions. The other 5 above it are process that's reserved for the body, right? For the board members. So, you know, that's how they call themselves into session and, okay, yeah, you know, hear ye, and all that other fun stuff they do. So beings that appeal is the first one on the list. I think it's pretty much well established that if there are any appeals, don't you think those would be the first order of business? Maybe I'm just spitballing here, but that's just the way it's supposed to be, at least in so much as the way I'm understanding it. Then we should start to get into some of the main motions, right? Now, in number 24, you're going to see throughout the book, many of the processes, for example, parliamentary inquiries, are regarded as main motions, right? Even though they're listed as incidental motions, right? Points of order, parliamentary inquiry, and like requests for information. They're specifically categorized here as incidental motions, but are often treated as main motions, right? Or incidental main motions. So, you know, this is, again, you'll kind of, it's sort of a state by state thing, right? It just depends on how they've kind of progressed over time. So you'll get a feel for it as you go along. And so in so much as the your list of motions here, once you've established your cause, right, your appeal, the thing you want to do is you want to expunge everything that has happened, what that trespass was, right? So once they trespass the law, a right, right, because your rights are the law, that's just cause to expunge everything. Hence, like I said, don't go in there and say, well, they trespass my rights, blah, 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 blah. Well, if they're not following due process and you are, when it comes time for the board to do the up and down vote on it, and you can clearly articulate how and why you did, who do you think is going to get the come out with the upper hand on that one? The other person sitting in position of emolument on the clock, you can bet you they're packing their bags, right? So that's when you can take them to court and sue them as a man, which we'll get into court, torts and all that stuff in a future video. So the other one, when you're presenting your petition, right, your actual grievance, remonstrance, whatever it is you're going to do, if there's no provision in the actual legislative rules at that time, you can always enter it in with a motion number 40, right? So this is to consider petitions when no other provision for consideration of petitions is made by rules, right? So this is kind of a catch-all that would grant you standing to begin due process. So habeas corpus, right? What is it? Well, this is a writ employed to bring a person before a court, most frequently to ensure that the person's imprisonment or detention is not legal, or is not illegal, right? That's why I said, you can't just create a crime and then say, okay, you're guilty of this crime and I'm putting you in jail. No, you can't. No, you can't, right? That'd be a fundamental alteration of the letter of the law, wouldn't it? So, without going through and reading every bit of this PowerPoint's going to be posted for you guys. And also knowing and understanding there's different types of habeas, right? So for example, the top one here is a writ used to remove a person for trial from one county to another, to the county where the person allegedly committed the crime or committed the offense, right? So for example, if there's a bank robbery, it was 4 counties over and you did it, yeah, they'll transfer you over there. So the second one here is a writ used in civil cases to remove the case and also the body of the defendant from an inferior court to a superior court. So this one you might want to focus on a little bit. New evidence came to light. Brady, emoluments violations under Brady, for example, that's caused to expunge, right? We're going to revisit this case under this lawful principle here, right? The second one. So when you fill out your AO 242, you might want to make specific reference here if this is in fact where you're going, okay? So this writ has evolved from the 17th century. This also is certiorari, meaning into the Supreme Court. So again, if you follow due process and you submit this through the legislature, the court can exercise the Supreme Court can exercise its discretionary jurisdiction and certiorari, grant certiorari, right? Because you followed due process, right? Even utilizing the correct lawful principle, right? The correct habeas, the correct format, right? So again, you already know what they're going to claim about you. You prove them wrong by doing it the right way and watch what happens. It's a whole different animal. This one is a writ used in criminal cases to bring before a court a prisoner to be tried on charges other than those for which the prisoner is currently being confined, right? So you're in jail and they find out you had committed a bank robbery however many years ago and they just found out. Well, if you're already incarcerated, here's where they're gonna do that one. So this one is a writ used in civil cases to remove a prisoner from the court's custody into another court of which person may be sued, right? Once that person is removed from that position of emolument, they can be, right, they've been impeached, right, removed, had their emolument taken away, their office taken away, right? Now they're just a man off the clock, right? Because suits have to be in like kind. So, and of course, we've got, without going into every single one of these, okay, some of these have been usurped, right? Some of these processes exist here, some of them do not. So the just to go in with the generic definition, right? This is one of 4 of the great charters of the English liberty, right, from 1679, securing to English subjects speedy relief from all unlawful imprisonments, right? The treatise on arrest and false imprisonments is my buddy always likes to talk about, but there are others here. The other 3 great charters are Magna Carta, the Petition of Right, the Bill of Rights, right? The Habeas Corpus Act does not apply in Scotland. I always wondered about that. Excuse me. The corresponding statute is the Criminal Procedure Act of 1701. Of course, a statute deriving ultimately from the English statute and enacted in the United States as a constitutional guarantee of personal liberty. So again, the question becomes, am I on or am I off the clock here? Because we're still getting back to liberty interest, no matter how they slice it. Knowing and understanding that the only thing they have is a fake bill, right? Fake debt that they themselves created. Wait a minute, what? It's like I said, this is not going to end well for the bad actors now that we've uncovered their foreign emoluments business plan. Corruption. So, habeas corpus clause, constitutional law. Here we go. Now we're getting into constitutional law and constitutional arguments. Constitutional provisions allowing suspension of the writ of habeas corpus only when necessary to protect the public in times of rebellion or invasion. Right? So if you're a bad actor who's invading, you say, I want my right of habeas corpus. Well, if you don't belong here, that's not your right. You can't claim it. That's exactly what this says. So you're a foreign invader. So to put into perspective what that is, and that hurts your feelings, then don't break the law. That's all I'm going to tell you. I'm going to go into, this one here I've jokingly used once or twice. I was actually shocked that they actually executed it. No, this is the return of the wardship. There was another one that directs the sheriff to inquire if somebody is an idiot or not, basically meaning to be able to manage their own affairs. Anyway, mandamus, right? Again, like habeas corpus, there are different versions of mandamus. So knowing and understanding what an actual, the generic definition is, it's basically a writ used by a court to compel performance of a particular act by a lower court or governmental officer or body to correct a prior action or failure to act, right? The appeals court directed the lower court to drop the case against General Flynn, right? That's a general mandamus, right? Just a general way of looking at mandamus. So that would probably be something to the effect of one of these two here. And I believe it was, excuse me, maybe it was the alternative, a writ issued upon the first application for relief commanding the defendant or either to perform the act demanded or to appear before the court at a specific time to show cause for not performing it. So that direction from the higher appellate court to the lower subservient court could have also been an alternative mandamus. So again, there's also a quo warranto, right? Who are you and what are you doing here, basically, right? This is a common law writ used to inquire into the authority by which a public office is held or a franchise is claimed, right? Who are you and what are you doing here? Quo warranto, decusus, those two things basically kind of say the same thing to me. So, depending on exactly what you're talking about in context of your, of your process, whatever that would be. So, for example, you say, well, this jailhouse is a private corporation. So you could file a writ of quo warranto, which would be an action by which the state seeks to revoke a corporation's charter, right? Say, no, private corporations, you can't act under color of law. No. You cannot arbitrarily deprive rights and claim color of law. Wrong. Hence the Walking Dead and the corpse and all of that crap. So, hence the on the clock, off the clock argument. This is one of the reasons why I specifically stay with this one, right? It's short, it's sweet, it's to the point, because it raises the simple question: the person whose legal position is an issue, right? Without going into a whole long drawn out, not knowing which direction this thing is going to go. So, we're going to go into a little bit on quo warranto specifically in and of itself. And I believe Kirk's working on that right now, but can't say for 100% sure. So let's stick with this writ of Replevin and Seepit, right? This is Black's Law 10th, page 1491. This is an action for repossession of property that is both wrongfully taken and wrongfully detained. So that's an example of a conventional writ, which is a writ by which demands were sought to be recovered, right? The prime common law example, right, was the writ of covenant or proprietary writ. So in so much as what a writ of Replevin would induce is deliverance, right? This is in a Replevin action, a writ ordering the redelivery of goods to the owner, right? You stole my property, dude, you better bring it back. So here's the general definition, right, as it appears there. So a little bit of history on Replevin. Good text, by the way, here. Practical treatise on the law of Replevin. This is actually a very good text if you really want to study Replevin action, study this practical treatise, right? So without going into all of that, personal Replevin, here you go. For all you common law people out there, this is a common law, at common law, an action to replevy a person out of prison or out of another's custody. Personal Replevin has been largely superseded by the writ of habeas corpus as a means of investigating the legality of an imprisonment, right? So again, you want to claim personal Replevin leading to habeas corpus. That's why it's 20, hey, make life hard on yourself if you want. But I just said, I'm going to submit the AO 242 for the double trespass against me about a year ago now, which of course I did how long ago. And it's currently in process. It's being litigated. So those bad actors are going to jail. That's all I know. Replevin and Seepit. This one is one that was relative in my case, which is why I chose it, right? Where this was an action for the repossession of property that is both wrongfully taken and wrongfully detained, right? So again, the knowing and understanding, Replevin in the I think it's detinet, I think is how that's pronounced, but I could be wrong. This is repossession of property, right? Personal property, chattels, that type of thing. Not typically used in real property transactions. So, Replevin in debt and you. This is an action for damages resulting from the wrongful taking and detention of goods that have since been returned to the owner, right? So just because they return the property doesn't mean they're off the hook, right? Yeah, no, you ain't done yet. You broke the law, stupid. So a recaption, right? This is specific to, you say, well, I filed paperwork and they're just going to keep doing what they're doing. Well, if you've begun a replevin and they keep it up, you can keep hitting them with as many of these as you want. You can literally tie them up in their own process and there's not a damn thing they can do to you. This is a writ of recaption, is a writ allowing a plaintiff to recover goods and damages from a defendant who makes a second distress while a replevin action for previous distress is pending, right? You say, no, dude. What part of writ of replevin in process do you not understand? You were served a copy of it. And you're going to try this again. No, I'm going to hit you with a writ of recaption. Either way, they're still done. And that would be, for those of us on the clock, that's, again, a good defense against that, injury by fellow servant. I keep going right back to that. So there are benefits to incorporation. Whine and cry about that if you want to, but you want to claim and exercise proper status, standing, and jurisdiction as one who is the master of all you survey, right? Prove you can do that. No better way to do that than to incorporate and say, okay, here I am. Here's my status. Here's my standing, and here's my jurisdiction. So kick rocks. So writ of protection. Pay attention, moms. This one's for you girls. This is a writ issued to protect a witness in a judicial proceeding who is threatened with arrest, or a writ exempting anyone who's in the Crown service from arrest in a civil proceeding for a year and a day. So in other words, if you're incorporated and you're conducting and working, turning state's evidence and all that other stuff, investigating and all this stuff that I do, this is the writ of protection, finds its origins in English law here, right? No, I'm a fellow servant there, buddy, right? Hence injury by fellow servant. So there are advantages to being, as I keep saying, come on in, the swamp is fine. Now you're starting to wrap your head around why I say that. Another advantage of being incorporated, you can take supervisory control through this writ. Now, this is significant, especially against being held in contempt in Sharia law courts. Here's why. This is a writ issued, right? And you have standing to do this once you have jurisdiction. You issue it to the legislature and they sign off on it. This is a writ issued to correct an erroneous ruling made by a lower court, either when there is no right to appeal or when an appeal cannot provide adequate relief and the ruling will result in gross injustice. What would be the gross injustice? What, that these Islamists walk in here and pulled their shit, right? Their was that the Trojan horse crap that they've been trying to pull? They pull on everybody, right? Oh, we're peaceful, yeah, blah blah bullshit. Just saying. So this one is found on Black's Law 10th edition, page 1849, right? You can verify that. So benefits of incorporating. Of every one of them that I've utilized, this is probably another one of my personal favorites right here. I say, no, right? My company. I own it. My name on it. We've entered into a reciprocity agreement here, right? So I've already, conceded my advantages. Your turn, right? Because we're going to find out who benefited from all those ill-gotten gains as we go along here. So, writ of deceit. This one is, I'm just going to go ahead and just announce it. This one is going to be utilized against those fake news folks, trolls, right? You guys know who you are. This is a writ against one who deceives and damages another by acting in another's name. So if somebody's utilizing this name and disparaging either me or it, you guys know who I'm talking about. This one is going to be, I'm going to utilize this against them to the fullest extent of the letter of the law. Count on it. So don't forget your affirmative defense lists, right? As you go through those. Now, these are the accord and satisfaction, right? You've got an agreement, right? Hence what we just did, right? We had 2 reciprocity agreements between my client and complainant, and the prosecutor didn't disclose those to the court, those emoluments violations under Brady, right? That's an injury by fellow servant against my client as she's in training. So the rest of these are, basically as listed here, right? That's why fraud or bad faith, right? There it is. Injury by fellow servant, there it is, right? They're going to try to claim latches. No, not if there's an injury first. So something that was already decided, right? Yeah, no, you're not going to bring these foreign emoluments into my republic. Hence the reason that they've strategically withheld that definition from the dictionary. Remember Article 1, Section 9, Clause 8, right? That's, as far as I'm concerned, those bad actors can be tried under a statute of frauds for all I care, right? They wrote that shit. They're bound to it, not me. So just a brief review here, and I mean extremely brief, what we just covered. Recap the important points for anyone who may have missed them. Do you know your standing, right? Hence the reason for incorporation. Do you know your affirmative defenses, right? Where to find them? Court rules, legal dictionary, stuff we just went through. Is performance a relevant question and why, right? Remember, there's going to be a specific performance question, right? What is it you wanted? What didn't they do? Okay. So, look for the stuff that's supposed to be there that isn't there. Prove that negative, right? Can you articulate why? Who can and cannot participate and why, right? Or why not? And for that, you can find that in the rules of the quorum, right? On page 331 of Mason's manual. So just to kind of go through, and now that we have pretty much covered, right, what juris, color of law, and diction, letter of the law, what this looks like in context, right? Now we've got a clear picture, right, including on the clock, right? If you don't understand what on the clock means, how are you going to utilize it off the clock, right? Because it's there to do the job that you put it there to do. So you're standing to control it off the clock, right? You see where I'm going with this? So anyway, stemming from the root word emolumentum, right? There's your fulcrum right there. It's here at the point at the center where the colors meet, not down here where we've been led to believe, all the corporate guys. So if my corporate gurus are watching it, we've been had, guys. We were told market advantage was where we needed to focus. It's not. It's right here where the market, margin, and capital meet, right? This is where we need to make sure we focus moving forward if we're going to be writing lawful contracts, right? So the weakness, right? You're you're not crazy, only cleverly deceived, right? So what's the deceit? Here it is right here. Found it. So as my kid's mother has probably informed you, correctly so, if there's a fight, guaranteed my ex-husband's in the middle of it. Oh, she's not wrong. She knows me too well. So hence the lack of a definition, right? Where the red underline there is foreign emoluments clause, Article 1, Section 9, Clause 8. There's your weakness, ladies and gentlemen. So now that we know what it is, let's fix it. And with that, thank you for watching. I hope you found this content helpful, especially for those of you who are reviewing. And again, if you want to help us out, help me out here in the, as I go along, right? My PayPal is, of course, my email, eclausllc@gmail.com. Please don't forget the LLC. Cash App is the $, capital E, capital C, LAUSE 2020. Watch out for those fakers. And if you want to join Patreon and have full access to everything that fits in context of every one of these processes that we've already executed, including in where we can. Now, we can't always do that, but where we can even publish what the judge said. So sometimes the people have requested that we don't do that, and we honor that request. If they're willing to release the information, we will do so. So that's just so you guys know that. And don't forget your gear. Stop by the online store. You can find the link to this at the Patreon site and various other social media sites. This is, you can t-shirts, long sleeve hoodies, little onesie for the kids. I got coffee cups on there, all kinds of good stuff. So again, thanks you for your support and everything you guys have already done. And we still got some work to do. We're going to get that definition. We're going to get that written, right? We're going to close up that hole. So hope everybody enjoyed, and look forward to seeing you guys on the show with Kirk on our regularly scheduled programming. Thanks, everyone.